Hey students, good to be with you all again. Today we're going to look at our second lecture, Judicial System, Litigation, Alternative Dispute Resolutions. So we just go now to your outline and we'll start our lecture here, okay? First of all, let's look at our court systems. We talked a little bit about court systems yesterday, or the last lecture that we had. In Alabama, let's look at a criminal case first. Remember we talked about you have jurisdiction misdemeanors. The district court has jurisdiction to do misdemeanors. A misdemeanor is a crime that you would get not more than a year in the county jail. A felony is where you can get a year and a day up to death for that. So if you have a misdemeanor in a criminal case, the district court would have jurisdiction to do that. And your municipal courts would also have jurisdiction. Like, for instance, the city of Huntsville has a municipal court. Town of New Hope has one. Owens Crossroads, Gurley, Madison. A lot of little communities have a court system. They have jurisdiction to do misdemeanor cases. Now they can't do felony cases and they can't do jury trials. Remember we talked about that yesterday. Now again, we'll go through this lecture and I'll go through some of our test questions here. Not all of them, but some of them. So we're talking about the criminal cases now. So now the circuit court has jurisdiction to have jury trials, have felony cases, in any case that's been appealed from the municipal court or the district court. If you have a criminal case, let's say a DUI, and you get convicted of that in municipal court, you can appeal that and get a trial de novo in circuit court. Be sure to, free legal advice here, if you do that, if you appeal a case where you're convicted in city court, whatever municipal court or district court, and you're going to appeal that case, that misdemeanor, to circuit court, be sure to put on your appeal bond, defendant demands a trial by struck jury. Sign it and date it, because if you don't put that, you're not going to get a jury trial, and then you're going to be in worse shape than you were in the lower court, I promise you. Okay, because if you appeal that case, you're appealing to get a jury trial. Judges hear all the time, my client only had 2 drinks. They don't buy it, generally. The juries are more lenient, if you will, when they're hearing cases. So if you have a misdemeanor case in district court or city court and you want to appeal it and get a trial de novo, be sure to put that on your appeal bond. Defendant demands a trial by struck jury, date it and sign it, so you can get a jury trial. If you appeal it and you think didn't put that on the appeal bond, you're not going to get that. So if a person has a felony case, you have a different procedure. We'll talk about that some more later on. We talked a little bit about it in our first lecture. But if it's a felony case, the circuit court would have jurisdiction to do that, to have that case in Alabama be circuit court. Now in federal court, criminal case, your lower court is called magistrate's court. That's like the district court. You can do misdemeanors and preliminary hearings and felony cases. That's what you have in the state district court. But in the federal case, that lower court is called magistrate court. And the trial level court is called the United States District Court. It's a little confusing because in the federal court, the trial level court is the U.S. District Court. In Alabama, where you get your jury trial would be the circuit court. Okay. Now in federal court, again, district court is your trial level court. If you would appeal it to, like, say, the 11th Circuit Court of Appeals, that's your federal appellate court that you would go to before you go to the United States Supreme Court. So in Alabama, you would have district court, okay, it's lower court. Then you have the circuit court where you would have the jury trial. And if you appeal that, you would go to the Alabama Court of Criminal Appeals and the United States Supreme Court. That's your appellate process, and that's your court systems in the state court. In the federal court system, U.S. Magistrate Court is your lowest court. U.S. District Court is where you would get your jury trial, and that's where most of the cases would start in the United States District Court. Then you would appeal that. If you lose, you appeal 11th Circuit Court of Appeals, and then to the United States Supreme Court. Right, that's the criminal side. The civil side is if you file a lawsuit, any lawsuit that you ask for a jury trial, you would file that in circuit court. If it's a divorce case, it has to go to circuit court. Some cases, we talked about the first lecture, the circuit court would have jurisdiction to do those cases. Remember, we said you could not have a jury trial in state district court. You can only have it in the state circuit court. Okay, so we're talking about a civil case now. So if a lawsuit's filed, it can, if it's less than $10,000, it can be filed in district court, but you would not get a jury trial. You have small claims court; those are in district court. Okay, you don't have a jury trial there. You have a judge trying the case. You do not have a jury trial in district court. Okay, you might see that on television sometime when you see when you have the cases and they don't have a jury. They have two people come in just doing the small claims court cases, if you will. Those are district court judges that do that, not circuit judges. So in a civil case, if it's less than $10,000, it can be filed in district court, but you can file any case in the circuit court if you want a jury trial. Okay, if you appeal that, you would go, if it's like a workman's compensation case or a domestic relation case, Alabama Court of Civil Appeals, then the Alabama Supreme Court. Okay, so that's your court system, your state civil case. Now, in a federal civil case, you would generally file your complaint, your lawsuit in United States District Court. That's where the case would generally start, would be United States District Court, and where you'd ask for a jury trial. In a civil case, I mean, we talked about the difference between civil case and criminal case in our first lecture. Okay, then the case would go, if you appeal that, you would go to the 11th Circuit Court of Appeals in federal court, and then the United States Supreme Court. You would, if you lose in a federal case, you would file a petition for writ of certiorari in the United States Supreme Court. The United States Supreme Court hears very, very few cases. Just because you appeal a case to the United States Supreme Court don't mean they're going to hear it. Okay, they hear very few cases. They hear the only cases that they want to hear. Okay, and that would be by you file a petition for certiorari, and that's how you would ask them to consider the case, ask them to take the appeal. But that don't mean they're going to take it. They take very few cases when you appeal a case to the United States Supreme Court. And it's a different process. I won't go through all that. That'd be you could talk about that for the rest of the term, or semester, if you will. I've appealed a number of cases to the United States Supreme Court. It's different going there than it is, like say, the state Supreme Court. All right. And some of these municipal places, some of these places that you get arrested, I've got a call one time where my client's mother, he'd been arrested in South Georgia. He had trafficking in cocaine, and apparently was going from here to Miami, but I don't know, he was going through South Georgia. Anyway, when I got to him, they told me that where he was locked up. Well, he wasn't really locked up. It was him and a bunch of guys in their underwear and a t-shirt, and he was in a chicken coop. This is in South Georgia, and had a guard out there with a gun and everything. So you think you're in a different time and age. Sometimes you go down to these places and you think, well, I didn't even know they had a town here. I didn't even know I didn't know it was on the map. Well, sometimes that's where people get arrested, and that's where you end up having to try your case. And where you try your case is different. If you're trying a case in Los Angeles, it's not like trying a case in South Georgia or whatever. If you're trying a case in Huntsville, it's not like trying a case like in Coleman or Decatur even. All right, you have different juries. You have a different jury pool, if you will. So anyway, that's just a little, don't have anything to do with, it's not on test or anything, but it's kind of interesting. You might want to know that, so it's kind of general understanding. So now that's the court system. That's the state court system in the criminal case and the state court system in the civil case. All right. Now let's look at our notes here real quick here. Let's look at number 20 here. It says long-arm jurisdiction allows courts to exercise jurisdiction over a non-resident person or business. All right. Now, what that means is if a person, let's say a truck from a corporation out of Chicago is driving through Alabama, and that truck runs into your client and runs into you and hurts you real bad, tractor-trailer truck. All right, and the driver's from Chicago, the owner of the truck company is from Chicago, the owner of the company that's putting the stuff in the truck is from Chicago. If you got to go to Chicago to sue these people, Answer no, because of the long arm statute. Every state has a long arm statute. You can sue that person in the state of Alabama, and they'd have to come here where the accident happened. They'd have to come here, and you can get jurisdiction over them. Otherwise, if you didn't have these long arm statutes, they could say, well, you got to come to Chicago and sue me. Well, you could, but you'd rather sue them in the state of Alabama, because that's where your client is. It's where you live. You don't have to go to Chicago and hire a Chicago lawyer, or Los Angeles, wherever. You want to do it. You want to do that here in the state of Alabama, where the accident happened, where it occurred, or if it's a contract, where the contract was negotiated. A lot of times, the contracts, when you sign a contract, they'll have in that contract that the law of the state of Alabama applies, or the law of Mississippi applies, or the law of that. Now, you be kind of careful about that. Now, if you sign a contract, in a business, sign a contract, and the other side wants you to say, well, the law of their state applies. It could be law of, let's say, the law of Vermont, law of Delaware, law of New York. Okay, well, you're in Huntsville, you're in Alabama, so you would want to pay attention to that. If you have a problem and you want the case tried in Alabama, put that in the contract. The law of Alabama applies in the case of a breach of contract. And we'll talk some more of that when we talk about contract law. Okay, now let's look at the next thing we got here. Number 22 is that most federal cases originate in U.S. District Court. We've already talked about that, haven't we? If it's a federal case, if you're going to file a federal case, civil case, you would generally file that in the United States District Court, would be a civil case. Now, if it's a criminal case, then it's going to go through the criminal procedure process. You'd have a preliminary hearing in magistrate's court, and you'd have your jury trial in federal court, okay? And that'd be the federal court system, all right? But if you file a civil case in federal court, then you generally would file it in U.S. District Court, all right? Now, keep it in mind now, all right? We're talking about civil cases. Remember, we know the difference between a civil case and a criminal case, don't we? And we know now the process you go through in a criminal case. We'll talk about that some more later on, but generally we know that. If you're in a state case, we know the process you go through in a misdemeanor case. It would be in the municipal court or district court, and you could appeal it and get a trial de novo and jury trial in circuit court. If it's a felony case, you have the arrest, you have the preliminary hearing in district court, the grand jury in the district attorney's office, and you have your jury trial in circuit court. In a federal case, magistrate's court, U.S. Attorney's Office does the grand jury indictment, and then you have your trial in U.S. District Court. So you have state and federal cases, okay? All right, now, let's look at the next thing we got here. Number 23, discovery in a civil case, interrogatories, depositions, motions to produce, okay? Now, let's look at that. Interrogatories are written questions. Now, we're in a civil case now, all right? And we're talking about discovery. Okay, we got a car wreck, or we got a breach of contract case, any civil case, not criminal, but civil. Okay. By the way, I always tell young lawyers this when they come in here to work for us at this firm. I always tell them that there's no excuse for you not knowing what's going to happen in a civil case. The reason for that is that you have so many ways for discovery. One way is interrogatories. Those are questions that you propound, that you send to the other party for their client to answer. Now, you send the questions, it can be 100 questions. You send all these questions and send them to the other side's lawyer. They get their client in the office, and they answer those interrogatories and send them back to you. I don't like to do that. I don't like interrogatories. I think it's kind of a waste of time. All right, a lot of lawyers do it, but I'd rather take a deposition. Now, a deposition is where you send a subpoena to any witness that you want to talk to, or the other party. In the case, if you're suing somebody, if you've had a car wreck and you're suing somebody, your lawyer should want to take their deposition and all the witnesses in the case. And you can do that in a civil case. All right, you can make them come in your office. You have a court reporter there. The person's put under oath. And the lawyer can ask them questions, and it's wide ranging. You can ask them any question which may lead to discoverable information. You got a lot more latitude in the deposition you do in that. I can point over there because that's where the courthouse is. My office is right across from the courthouse. I'm on the east side of the square, so I'm pointing over there because that's where the courthouse is. So when I point there, I'm saying, well, that because I'm used to going over there. So if you're going to take that deposition, all right, you have that person come in your office. You have a court reporter there, you put them under oath, and you start asking them questions. Again, wide ranging. You couldn't ask those type of questions again in trial, all right? But you can ask any questions can lead to discoverable information. That's the reason there's no excuse for any lawyer in a civil case not to know what the witnesses are going to say in a civil case. You never know what a jury's going to do. Any lawyer that ever tells you, hey, I know what the jury's going to do, don't hire that lawyer, because that lawyer's lying. They don't know. Nobody knows what a jury's going to do, okay? Now, you can take depositions. You know what all the witnesses are going to say, but you don't know what a jury's going to do, okay? In any case, we'll talk about that a number of times. By the way, you're going to probably get sick of hearing me say that in this case, in this class, because you never do. This is, again, and I've told you, I keep telling you, this is not mathematics. It is not physics. You're dealing with my life. Now, a lot of lawyers that do like to do real estate closings and copyright patents and contracts, they know exactly what's going to happen, okay, because it's right there in their office. Now, if you get in some kind of breach of contract or some kind of fraud case or something, and you got to go to trial, they don't know what's going to happen. You know, trial lawyers don't even know what's going to happen because you don't know what the jury is going to do, okay? So let's keep going. So you got the deposition, you got the person in here, you got them under oath, all right? I've had cases where I've had my investigators have information on the person I'm taking the deposition of, and you ask the person, okay, were you at a certain hotel? Were you in room 311? It's this hotel on the evening of so-and-so, so-and-so. And they say no. And I say to the person in the deposition here in my office, and this happens more than you would think, because I have my investigator check on, a lot of times before I take a person's deposition, my investigator does a lot of checking, okay? That's what happens if you got a good lawyer. So you ask that question, and the person says, no, I wasn't there. All right, well, I said, now you're under oath, and you understand that you're under oath in this deposition just like you've been under oath at trial, and you can go to prison for perjury, for lying in this office, just like you can if you lie on the witness stand over in that courthouse over there. You understand that? The person says, yeah, I understand it. I'm going to ask you again, was you in room 311? So, no, I wasn't. All right. Then I rolled the TV in, and I put the DVD in, I put whatever the computer, whatever my investigator got, hook it up. Here, is this you coming out of room 311 on this date that I just asked you? Is that you? Is that somebody else? It looks a lot like you. Is that you? Well, it looks like me. Well, because it is you. Now, you lied. And at that point, a lot of times you settle your case because that person don't want to go to court because they lied. You caught them in a lie, didn't you? Now, by the way, once you catch a person in a lie, and if it's in the courtroom and the jury hears it, a lot of times that ball game's over. All right. So that's what the deposition's for. So you know what that person. Now, what if a person says something in your deposition? This happens all the time. You take a deposition, and a year later you're in court, and the person says something different on the witness stand in front of the jury than they did in that deposition. You say, let me turn to page 81 at line 14. Let me ask you this. Did I ask you this same question I just got through asking you just a while ago? Did I ask you that same question in my office? Yeah, you did. Read it to the jury. He reads it. Reads your answer. Read it, and they read the answer. Well, that's different than what you just said on the witness in front of this jury. Is it? Well, I don't know. No, I just want you to know. I want to ask you, are you lying now or were you lying then? Because you're under oath both times. Now, you got the person, juries don't like people get on the witness stand and lie. But that's the importance of a deposition. Okay, that's the reason you should take depositions. All right, now, another way you can get discovery is motions to produce. You want a motion to produce the person's tax records, business records, whatever case it is you want all the records of the other side. Whatever the case is about, you want whatever record you file a motion to produce. If they don't produce all the records, then you can get sanctions, and you can actually win your case through sanctions if the other side don't comply with the motions to produce. But depositions are the best way to get discovery, I think, in a civil case. Now, what about a criminal case? What about discovery in a criminal case? All right, let's suppose this. Suppose you're a witness to a murder. And my investigator comes up to you, your house, knocks on your door, your apartment, and says, I'm investigator for Mark McDaniel. He's defending so-and-so in this murder case. And I understand you was a witness to that, and would you mind talking to me? And you say, no, get off my porch, or get out. I'm not going to talk to you. What can my investigator do? Nothing. First time I'm going to hear what you got to say is on that witness stand in that criminal case. I can't take your deposition. Can't take your deposition in a criminal case. Can't do interrogatories. I can't file I'm filing motion for discovery, where the state's got to give me anything which may be exculpatory. We'll talk about this later on. If they got some information to clear my client, they got to give it to me. But I can't take a deposition in a criminal case. I can't file interrogatories. I can't file motions for dues. I can file motion for discovery, but that's very limited what they got to give me. Anything that may clear my client, other than that, they don't have to give me. They don't have to give me a witness if they want to. Okay. So that's the difference in the civil. You'd think it'd be just exactly the opposite. You think if a person's freedom of life is at stake, you'd have more right to get information than you would if you're suing for money or some kind of breach of contract or something, wouldn't you? But it's not that way. In a civil case, you have all these discovery methods that you don't have in a criminal case. By the way, if you was a witness to a car wreck in a civil case, and I was representing the person that was suing, and I was representing the plaintiff, and you was a witness, saw your name on a witness list on the accident report that you was a witness, and my investigator comes up and knocks on your door and says, I understand you was a witness to this car wreck on so-and-so such a date, and you say, yes, it was. And my investigator said, well, I kind of talked to you. And you said, no, get off my porch. My investigator was going to hand you a subpoena to be in my office for a deposition. And if you're not there, I'm going to have a deputy sheriff pick you up and bring you to me. Okay? So you'll be there. But I can't do it in the criminal case. I don't have any discovery. Then my investigator can go out there and hustle around, try to find out witnesses and go to wherever the murder happened, whatever case you're doing, whatever, try to find information for me. But I can't get a person to do a deposition. I don't have that kind of discovery in a criminal case. All right, so that's the different kind of discovery methods there, okay? Number 24, burden of proof in a civil case, is that which establishes the case by preponderance of the evidence. All right, there you go. And you say, okay, now I'm getting sued for everything I'm worth. You listen to this right now, and you're not getting sued, but let's suppose you get in a situation where you're getting sued for everything you're worth. And you go to the lawyer's office, and the lawyer says, well, if we go to trial, the plaintiff's got to prove their case by preponderance of the evidence. And you say, well, what is that? Well, if you see the scales of justice, that's tilting them ever so slightly. So the plaintiff's got to tilt the scales ever so slightly, more likely than not. Preponderance of the evidence, greater weight of the evidence. It's going 1 inch over the 50-yard line. I've explained it all kinds of different ways to a jury. Okay, so if you're the plaintiff, if the person suing you, you've got to prove the case in a civil case by preponderance of the evidence. You say, no, you got to do better than that now, Mr. McDaniel. You got to do better than that. You got to give me a formula. You got to because you can't tell me that everything that I've worked for is at stake on that. No, that you got, remember the substantive evidence, we talked about substantive evidence last week, or the last lecture. They got to prove if it's a negligence case, duty of care, breach of duty of care, proximate cause damage, they got to prove those elements of the tort action we'll talk about later on. And they got to prove those elements by preponderance of the evidence. And that's the greater weight of the evidence. That's going 1 inch over the 50-yard line. Okay? Then if they prove that case, then it becomes a matter of damages. And you think, well, that's kind of scary. Yeah, it is kind of scary. The jury decides that. In a criminal case, the burden of proof is beyond a reasonable doubt. That burden is tilting scales are just like this. I mean, beyond reasonable doubt's the highest burden, because before you can take a person's life or liberty, the law says the burden of proof is beyond a reasonable doubt. Okay, not a fanciful doubt, but a reasonable doubt. Okay, and then, well, what's a reasonable doubt? It's what a reasonable person would say. There you go. Remember what he said first place? Reasonable, beyond a reasonable doubt. So all 12 jurors in a criminal case have to agree that the state or the government proved their case beyond a reasonable doubt. Okay, so if they don't, then they should acquit your client, find your client not guilty. Okay, so the civil case, preponderance of the evidence. All right, in the criminal case, it's beyond a reasonable doubt. With insanity as a defense, we'll talk about when we get a criminal case. The defense lawyer has the burden of proving insanity by clear and convincing evidence, but we'll do that. That's a preponderance, clear and convincing, beyond a reasonable doubt. All right, but we'll talk about that when we get to the criminal case about the insanity defense. Okay, so we got the burden of proof there. Number 25, the method by which U.S. Supreme Court voluntarily reviews an appeal is certiorari. We've already talked about that, petition for writ of certiorari. The greatest changes in the written Constitution have been brought about by judicial interpretation. And we've already talked about that. We talked about that in stare decisis and precedent, didn't we? Like we talked about it, that was in number 1. Stare decisis means stand by the decision dash precedent. Okay, precedent. So that's if you look at that, that's the same thing. The greatest change in the written Constitution has been brought about by judicial interpretation. I think you've seen that again. We talked about Roe versus Wade in the Dobbs decision. So is there anything in the Constitution talking about Roe versus Wade? Does it say that in the Constitution? No. Does anything say about the Dobbs decision? No. It's judicial interpretation. If 5 of the 9 justices on the Supreme Court, if they interpret the Constitution a certain way, you know what? That's what it is. And it is that until you get 5 judges to change that. All right? That's it. And that binds every circuit court, every U.S. district court. It binds New Hope City Court, Town Court, okay, or Owens Crossroads Court, Gurley Court, Madison Court. That case in South Georgia, you know, I won't even say what. I'm not going to say what town it was. Anyway, it was a nice little town, and I won the case down there, so I kind of like that little place, even though my client was in chicken coop for a while. But anyway, it applies to the Supreme Court. The Supreme Court decisions apply everywhere once they make that decision, and that's judicial interpretation. And you say, well, those judges are wrong. Well, that's there on the United States Supreme Court, and the only way you change that is you get another Supreme Court. They have lifetime appointments, and if they die or retire, then whoever the president is appoints the person, Supreme Court justice, and the Senate confirms them. And that's how it goes. That's forever, any U.S. district court, appellate court, or United States Supreme Court, and they all have lifetime appointments. That's not the way it is in state courts. State judges are elected. By the way, can you name me any of the Alabama Supreme Court justices? Just think about it. You elect them. Can you name me any judges on the Alabama Court of Criminal Appeals? 5 of them. You elect them. Alabama Court of Civil Appeals. 5 judges on Alabama Court. You know any of those? Can you name any of them? You elect them. Can you name any of our circuit judges in Madison County or Limestone County or Morgan County? You elect them. Any district judges? Can you name any of those judges? You elect them, okay? You don't elect federal judges. They get appointed and by the president, confirmed by the Senate, but you elect your judges in the state of Alabama. In most states, you do elect them, okay? So they don't have lifetime appointments. They run, every 6 years they run, and you elect them, all right? So let's keep going here and now. So we got to talk about the written Constitution, about judicial interpretation and how important that is. And, the judge can be a public order advocate, That can be their judicial philosophy. They can be an individual rights advocate. That would be a different judicial issue there, or the way they look at things. A public order advocate judge is going to be more inclined to rule in a conservative manner. You've got an individual rights advocate's judicial philosophy that would be more individual for the individual rights, and they would be more liberal justice. Who's right? Who's wrong? It's their judicial philosophy. People say philosophy don't mean. Philosophy means a lot. Philosophy means a whole lot, because that's how you look at something and how you interpret that Constitution. And you say, well, it should be interpreted like the founding fathers meant for it to be interpreted. We'll talk about that some in our next lecture, okay? When we talk about the different amendments to the Constitution and the Bill of Rights, if you will, talk about that. But again, the judicial philosophy that a judge has is very important. If somebody's going to sentence you or one of your close friends or relatives, and that judge has a certain judicial philosophy, that could depend on what kind of sentence you're going to get. That really have a whole lot to do with it. Whether that judge, as an individual rights advocate, believes you should get a break and get some help, or your friend get some help, or whether they just put you in jail and throw away the key. Recently, there came out that Alabama has more people locked up than any nation in the world except El Salvador. That we have more people in Alabama per capita locked up than any nation in the world except El Salvador. Okay. Now, Alabama, Mississippi, Louisiana, Arkansas, and Oklahoma, we're usually in the top 5 as far as number of people locked up per capita in our states. It's not like number 1 in the nation in football or basketball or baseball, but these 5 states generally swap out who's number 1, who's number 2, 3, 4, and 5. I've taught advanced criminology in different universities, and that's not about this lecture is about law. But if it was about advanced criminology, we'd have a long discussion about that now, about why that is and why you got how many people on death row in our state per capita versus other states. Some states don't even have death penalty. Some states do. And we would have a long discussion about that, but this is not advanced criminology. This is business law 211, and so that's what we're going to cover in this class. All right, let's keep going. Well, but we'll talk about other things too, because we got time to do it. Now let's look at mediation and arbitration. All right. So we'll look at this first. Distinguish mediation and arbitration. Well, first of all, mediation is advisory. Arbitration is binding. Mediation is if you like peace and you like to solve problems, you can make a really good living. You go to law school and get your law degree, and you become a mediator. Now, what a mediator does is you got 2 people coming into you. It could be a domestic case, but it won't be a criminal case. You don't do that. You don't do this criminal case. It's only a civil case. I represented 26. We had a Lehigh bus case several years ago, where 26 young people were injured. Many young people were injured, and 4 of the young people died. I had 2 of the death cases and 26 of the injury cases. And when you sue a big corporation, they don't just write you a check. We had to have the interstate closed down here on a Sunday afternoon, where that bus went over that rail and hurt and killed those children. We had to pay for that. We had the best accident reconstructionists in the nation. We felt like they were from Denver. We had flown in here. Had to pay for that, by the way. When you take a civil case on, and the client generally don't have the money to fight the big corporations. You have to front that money for the case, and you have to hire expert witnesses and the like. So we filed a lawsuit, and like all of cases when we talk about products liability in this one of our lectures, the big companies don't just write you a check. You have to go through. We just got through doing one, and we went to Supreme Court 3 times on it, and just got it settled after 7 years. 7 years. Our client got blown up, she got blown up. It took 7 years to get that case done. But anyway, let's go back to, in those cases where all the bus cases were mediated, and eventually they were. But it takes a long time. So anyway, what is mediation? You got two parties coming in. You got, this party says, okay, I want $10 million in the accident case. And this side over here says, I don't want to pay him anything. So you have a mediation. You have them come into the office. You go to the mediator's office. All right, the mediator comes into the room of the plaintiff and says, how much do you really want? You're not going to get $10 million. Well, I want $9 million. All right, mediator, I'm going to really make this short, but I mean, it takes a while. So the mediator then goes to the other room and says to the defense lawyers, insurance company lawyers, I'm making progress over here. Now, I'm not going to tell you what they want, but they come down. They're making progress. What will you pay them? We'll pay them $10,000. All right, so now we're at $9 million over here and $10,000 over here. Now you say it ain't going to work. Now I'm not a mediator. I've never done mediation. I've been to many mediations, but I'm not a mediator. I'm a trial lawyer. I'm an advocate. I go to court. I try cases. I admire mediators because they got so much patience. But my thing, when they come back, I said, what did they say? What are they offering? And the mediator said, well, I'm not going to tell you what they are, but they're offering something. When we started, they wasn't offering anything. Now tell me what you really want. I mean, come on, let's get real here. What do you really want on this case? What do you really think it's worth? Well, $8,500,000. I'll take that. $8,500,000. Go back to the other room. We're making a lot of progress over here. You guys aren't doing anything here. You guys you're not working in good faith. Your insurance company, you're not operating in good faith. Oh, well, we'll come up to $100,000. All right, now we're at $8,500,000, $100,000. Mediator goes back, says, hey, these guys just really came up. We're making progress. Now, you think this is never going to get settled. Well, according to who the mediator is. And the lawyers, we know who the good mediators are. And if you like to make peace, you'd be a great mediator. I'm not a great mediator because I like to advocate. But if you do like that, I mean, in big cases, I mean, I won't tell you how much both sides have to pay the mediator. Okay, whether or not you settle it or not, the mediator gets paid. And you know, I've had cases where we hire mediators come out of it, Miami, different places. I mean, and you got some really, really good ones here in Huntsville, Birmingham, really, really good mediators. And they work hard to settle cases. And judges want cases settled because there's so many cases and it's such a big backlog that it's just unbelievable. And so they like to get cases settled. Divorce cases about all divorce cases are mediated. But, child custody and alimony and child support and all that. You have really good mediators that can do that. I was in a mediation in Houston, and we started at 8 o'clock in the morning, and I wanted to leave. I mean, I thought it was over. I said, by 8:30, I was telling my client, we're out of here. This thing's not going to work. And at 2 o'clock in the morning, it settled. Started 8 in the morning, all day long, and that mediator was so good that she just kept us there. Okay, they give you free lunch. Well, you ain't free. We're paying for it, but you get lunch. You don't get dinner. So you're sitting there. You eating crackers and drinking Dr. Pepper, whatever you like. And so you're getting kind of hungry, whatever. But anyway, that case settled. That's the longest one I've had to go. But I've had a lot of them go a long, long, long time. But the mediator, if the mediator can keep you in that room and keep it going, a lot of times you don't settle it, but you get close enough to where you do settle it. So that's mediation. Mediation it's not binding. If the mediator can get it settled, and that's great. Now, arbitration is binding. If you sign an arbitration, if you buy something you sign an arbitration agreement, then that's you have to go to arbitration. Now, what's arbitration? Arbitration is just like going to court. You can have arbitration, in your classroom at UAH. You could have a arbitration. You have a plaintiff lawyer, defense lawyer come in there. You got an arbitrator sitting there, and you got a court reporter. You have witnesses coming in, and whatever the arbitrator decides, that's it. That's binding. You can't appeal that. There is no appeal to arbitration unless there's some kind of fraud or something like that. Then you could get it set aside and get another arbitration. But arbitration is binding. Mediation is not binding. Okay. Let's see here. Let me, before we go any further on our lecture, let me get some of these questions here, and then we'll pick up on some of these other points here. Let's look at some of these questions here before we move on here. Let's look at this right here. Now, again, these are exact questions here, okay, that you're going to have on the test. All right, let's see here. Most federal cases originate in the A, U.S. Circuit Court of Appeals, B, U.S. District Court, B, isn't it? So the answer, that's B. One method by which parties can gather evidence about their case is A, certiorari, B, stare decisis, C, deposition, answer C, okay? The burden of proof in a civil case is A, which establishes absolute certainty, B, equivalent to clear and convincing evidence, C, beyond a reasonable doubt, D, which establishes preponderance of the evidence. Answer D, civil case, burden of proof is preponderance of the evidence. Next, and here's another question. Method by which U.S. Supreme Court can voluntarily review an appeal. A, certiorari, there's your answer. We don't need to do B, C, and D, do we? Next number, written questions presented to parties to discover information pertinent to the lawsuit. A, certiorari, B, stare decisis, C, deposition, D, interrogatories. Answer D, interrogatories, okay? Next, the greatest changes to the written Constitution have been brought about by A, treaty, B, judicial interpretation. There's our answer, judicial interpretation there, okay? All right, and another one, the procedure in which the parties to a dispute submit to an impartial third person who actually resolves the dispute between the parties, okay? Actually resolves the dispute. Okay, A, arbitration, and your answer there is 31 is A, okay? Because the arbitration is, they decide. You can't appeal it. Mediation, the mediator goes back and forth, tries to settle the case, but the parties don't have to agree with an arbitration. That arbitrator decides the case. Now, there's a few more questions in this lecture, but they're like that. Let's see. You can see how these questions and tests are going to go. I want you to understand. I want everybody to do good on this. Is if I get this test stuff out of the way, maybe you learn. You say, well, I kind of want to. I like law. I want to listen to it more. Whatever. May not, but you might. And if we get some of these test questions out of the way, you won't have to worry about that as much. Okay. Okay. Which of the following is a benefit for using mediation as a means to resolve disputes? A, disputes are often settled more quickly through mediation than formal litigation. B, there are fewer formal rules in the mediation process. C, the mediator is selected by the parties. I didn't tell you about that, but they are. The parties have a list and they can decide who their mediator is going to be. And D, all of the above, and the answer is D, all of the above. Those are reasons that you would have mediation. So D would be the answer in that one right there, okay? So there's a good bit of the questions on that lecture there. Let's see, distinguish. Okay, number 28, the arbitrator's decision cannot be appealed except on certain limited grounds. That's where there's fraud, okay? All right, when a state, let's look at here down to 36. I'm skipping some, but I'll do that in the next lecture, okay? Well, let's get 31 first. In some areas, the state and federal share the power. These powers are called concurrent. Okay. Now, Here's what that means. All right, suppose you have a drug case, okay? All right, now, in let's say the City of Huntsville Drug Task Force makes the arrest, trafficking in heroin or fentanyl, whatever, okay? They make the arrest. Can they turn that case over to the feds? The arrest was made by HPD, the drug unit, HPD's drug unit. All right? Can they turn, trafficking fentanyl, can they turn that over to the feds, the federal government, the feds? Answer, yes, because they have concurrent jurisdiction. You say, how is that? Because you have federal drug laws and state drug laws. So what they do is wherever you can get the longer sentence, a lot of times they'll turn it over to that. If the feds make a case and the state can get a longer sentence, then they can turn it over to the state because you got state drug laws. Now, what if a person commits a crime on the arsenal? Can they turn that over to the state? Answer, no. Okay, because it happened on a federal property, and the state does not have concurrent jurisdiction there. There's no concurrent jurisdiction there. It happened on the arsenal. If it's a DUI on the arsenal or some kind of drug case on the arsenal, it's a federal case. It's not. You cannot give it to the state because they don't have concurrent jurisdiction because it's on the federal property. Bank robbery, would that be that's a federal case? What about a bankruptcy? Could a state court do that? No, that's a federal issue. Okay, so some we won't have to learn all of them, but if there's concurrent jurisdiction, that means the state or the federal courts could handle it. And generally, you see it in drug cases where the state makes a case, turns over to the feds make it, or gun cases. It could be gun cases, whatever, where they have concurrent jurisdiction, and they could turn it over to the other. So some cases where the state and the feds can handle the case, that's concurrent jurisdiction. Okay. Now let's look at 36 here. When a case can only be heard in state court, the state court has exclusive jurisdiction. What if we have a murder case in Madison County? Somebody robs a store and kills somebody, and it's Madison County, not on the arms, but Madison County. Could that be turned over to the feds? No, could not. That is a state case. What about a robbery that happens in Madison County or Limestone County? Can they turn that over to the feds? No, that's a state case. Burglary, can they turn it over? If it's on the arsenal, it's a federal case, but if it's Madison County, burglary, no. What about a rape? It's a state case, you can't turn it over to the feds. All right. Then we talked about if you bring a person across state lines, where it's not legal it's not legal in one state, but legal in one state, and you bring them across the state line to commit the sex offense where it's not legal in that state, then you have a federal violation, a Mann Act violation, which it would be a federal case then. Okay. So if it's concurrent, if the feds and the state can do it, it's concurrent jurisdiction. If only the state or only the feds can do it, then it's exclusive jurisdiction. Now, you don't have to learn all the different kind of cases, but that's what the test question will be. Okay, when a case can only be heard in state court, the state court has A, B, C, D, exclusive jurisdiction. Okay, and then you go back up to the other one. In some areas, the state and federal government share power. These powers are called A, B, C, D. Your answer is going to be concurrent there. Okay, I hope you're kind of getting the drift how this thing goes. If you take your first test, you'll see that hey, I heard that during the lecture. Yeah, you sure did, because that's I'm going to tell you a lot of them. I'm not going to tell you every one of them, although I think I just about did then. But anyway, I'll give you a lot of them, but the rest of them I can kind of look at your notes so you can figure it out. Well, so we got that got through our second lecture here, and we'll go through our next one. We'll have to talk about the Constitution, and I think we'll have a good time on that in our third lecture. With that, you folks have a great week, and I look forward to seeing you at the next lecture. Thank you so much.